In Nebraska, when you enter into a contract, be it oral or written, uh, you contract for a certain amount of services and then you agree to pay a certain amount for those services. Once that is completed, then that's the end of the contract and there is no more contract between you and the party you contracted with. If there are changes made to the contract during the contract period, that's called a novation. Now, novations have to be agreed to by both parties. You can't go out and unilaterally make a novation to the contract. In this particular case that you're talking about, you can't just contract to spray for weeds for $80 and then just keep providing services and charging the people, because that wasn't in the original contract. That's a novation that was made unilaterally by, in this case, the yard care company. That won't fly in court. The law does not promote that type of behavior in people. You can imagine if they did, if they rewarded that type of behavior, then people would do that constantly. All the service providers here in Omaha would just engage in that type of practice. There is a doctrine in the law called quantum merit. And what that says is that even if you and I do not have a contract, but I provide services for you and you benefit from those services, then you owe me a fair and reasonable amount for those services. Now, that would be accepted in this case because the services, there's no confusion that the services were not requested, the services were not contracted for in any way, and so it's my opinion that the quantum merit theory would not hold up in this case, especially in the case that you talked about where the parties have sent letters, they've sent texts, they've sent emails, whatever, to the yard care company saying, look it, we didn't contract for this, we don't want it, don't do it anymore, and then he continues to do it. The law would never promote that and allow him to prevail on a civil suit in that matter.
What would you recommend for people, who are being sued? What should they do if they feel this way, or this is their experience? How should they go forward now that they've possibly been subpoenaed?
Well, they should come in and definitely answer the suit. What happens is if they don't answer the suit within 30 days of being served with the lawsuit, then the yard care company will come in and take a default judgment for whatever amount it claimed in the petition. So that wouldn't be fair. The persons, the defendants in this case, would need to come in, usually with a lawyer. I'd highly recommend a lawyer, just because sometimes, or most of the time, when you try to do it on your own, it just never comes out the right way. But in any event, they would come in, the lawyer would come in and file motions that show that the lawsuit is frivolous in nature, that there's no basis for it in the law, and that it's being brought maliciously. What I would also do if I were those people, in order to recoup their costs and their attorney fees and things, is file a counterclaim for this malicious prosecution, so to speak. That the word prosecution usually connotes a criminal case, but it can also connote a civil case. Prosecution and service of summons. It was wrongfully done from what I know in these cases, and they could recover their damages in the form of attorney fees and court costs and that sort of thing.
Have you heard of somebody doing something like this? I mean, does this happen fairly frequently, or?
It doesn't happen frequently, but yes, I've heard of it before, where small business owners sometimes will get a misconception of the law, either intentionally or unintentionally, just negligently, and they'll proceed on the law thinking that that they can prevail. For instance, the quantum merit theory. It just wouldn't happen in this case, but I've seen small businesses think that they can prevail in that, and usually you see it more in terms of the small claims court than you do in county court, because generally when a lawyer becomes involved, he has a duty to say to his client, be it the yard care company or whoever, hey, these suits are frivolous, they don't have any legal merit, and I don't advise that you file them.